And I don't think we're going to go into recess because our time for our next argument has passed already, so we'll just give some time for moving back and forth.
I think opposing counsel might be in the
Conference room, waiting
room.
to,
Right.
that would be great, thank you.
Yeah.
This is the time set now for oral argument on State versus Hansen, our case number 2022-0178, and we'll take appearances from counsel.
Jennifer Foresta with the Public Defenders for Ms. Hansen.
Thank you, Ms. Foresta.
Your Honors, Christopher Ballard on behalf of the state.
Thank you, Mr. Ballard. You both are familiar with how we do things here, and so unless you have questions, we'll just proceed.
Maybe I'll reserve like 4. All right. Good morning. May it please the court. I'm here on behalf of Ms. Hansen, and what we're asking this court to do is find that the lower court erred when it denied the suppression motion regarding her statements. And we're asking you to reverse this conviction and remand it back for a new trial without the offending evidence. There's two main issues or two main parts of this, and that's basically the pre-Miranda statements and the post-Miranda statements. So I'm going to go ahead and start with the unwarned interview at the apartment, and we'll go from there because that affects really the considerations for both parts.
You can't win on the second unless you win on the first in some measure, right?
Yes.
Okay.
So in looking at this unwarned interview at the apartment, our position is that the government violated her privilege against self-incrimination when it compelled her to be interviewed but did not warn her of her rights. And as Miranda stated, the compulsion can be physical, but it can also be psychological. And the test that we have to determine if someone was in custody, because that's really the question, is it's hard to compel someone unless they're somehow under your authority. The test that came from the test that came from the Supreme Court is a two-part test, basically looking at whether the freedom of movement was curtailed. And then the second part, if the freedom of movement was curtailed, is the other totality of circumstances regarding.
Can I start you off with a question? It seems from the briefing like the parties' arguments on both of those two Miranda steps turn on differing views about the location, meaning the landing where they do that interview, and how it impacts it. You've stressed that it's fairly narrow, that the worker and the cop are sort of booking in, or the state has stressed that it's public. One of the things that occurred to me as I was watching the videos and reading the briefing and thinking about it, though, is it seems like in those initial moments where they're talking in this sort of entryway, it seems like she's the one that says, hey, let's go out on the landing. Do I have that wrong, or do you read those statements differently?
view it differently in the context than the state does. Those words came out of her mouth, but the context that it's coming in is that government agents have appeared on her doorstep, one of them representing the threat to take her child. They come into her apartment the second she cracks the door, and all of a sudden you have one agent, the DCFS agent, in between her and her child. You have another officer standing right there at the door, and you have another one on the landing. And the DCFS agent immediately starts telling the kid what to do. Like, why don't you go to the bedroom? And that is when Stephanie's like, oh, no, we'll take this outside.
Right, okay, that's the sort of backdrop to what I'm saying, though. It seems like in that exact moment you've identified, you're right, the DCFS worker is saying to the kid, hey, go somewhere else because we're gonna have this chat. And the defendant, Ms. Hansen, says, let's do it out there. One way to read her statement there is her saying, I'm comfortable out on the landing, right? Because otherwise, if she wasn't comfortable out on the landing, she wouldn't have said, hey, let's go talk out on the landing. That seems to be what the state's telling us about the import of that. Why is that wrong?
It's wrong because you have to look at the entire context. So you have to consider it with the fact that it's a response to a government agent starting to take control of the area and the situation. So we have them physically taking space. We have them starting to give instructions to her child and redirecting her child's movement. The only other option that she has at that point to get them away from her child is to move the entire situation outside.
Well, no, in theory, she could have gone with what DCFS worker suggested, which is, hey, honey, why don't you go into your bedroom and play with your toys for 20 minutes while I talk here in the living room, right? I mean.
But at no point is the option to not talk
Right, I totally agree with you.
And that is the problem we're really
Trust me,
talking
the other
about.
side is going to get a few questions along those lines. But in terms of the location of in terms of the location of where they end up talking, it does seem to have some significance.
6 feet.
Right, but it does seem to have some significance that they go to the place that she says, hey, let's go there.
Mm-hmm.
So it doesn't seem like she'd be pointing them to a place where she was manifestly uncomfortable. Fair or not fair?
No, look at her body language. She is manifestly uncomfortable. Just look at the body language. She's hunched over. She's crossed her arms. She's like looking between them. She's like rubbing her chest, which is like a sign of someone that's really uncomfortable. And she has no way to reestablish control over the situation other than to try to get these men away from like the inside of her home and her child, which they're trying to establish control on by telling her what to do, telling the kid what to do. There's just a limited amount of options here, none of which appears to be not engaging in the interview, which is really the big reason we're here. So whether she tells them, we can, yes, please, continue telling my child what to do and removing my child from this room, or I'm gonna step away so that you're no longer interacting with my child, but that's not a voluntary situation that she wanted to be engaging in. Yes, sir.
Still formulating the question, maybe.
Okay. Did that answer your question?
It did. I mean, this is just one of those sort of Rorschach tests. I think you can see that fact sort of different ways. Okay.
But I think you look, for curtailing the movement, you have to look at the totality. And so her movement was limited. The second they step a few feet out
Right.
onto the door, she has nowhere to go. She's not allowed to go back in. Officer Wong is standing there. There's no way for her to get in past him because there's a chair right there.
Right.
She can't go either way unless she's like physically pushing past one of the people, which is.
Isn't, I guess I've got formulated a couple of my questions.
All right.
One is, it's difficult to know whether she could have gone back in. Whether the officer inside the apartment would have allowed her in, we don't know that definitively, where she never tested that.
Well, we do know because his statements, that same officer is the officer that said, you don't have a choice, you're going out there to talk to them, and I'm staying right here. Those were his exact words. Like, I think the thing you really need to be looking at here is she was never informed that she had the right to decline the interview, that she had the right to leave their presence, that she had the right to eject them. She was never told that she had the right to remain silent. Instead, what she was told is that she was to participate in that interview. She was ordered 6 different times by the officers to participate in that interview.
And how many of those times occurred before she said, let's step outside? Because it seems like if those statements are made in terms of a reaction to the idea that we don't want the daughter to hear what you're saying as you're interviewed, then this is the way it's got to be. is that we need you two separated, that statement, among others, this is the way it's got to be. If that's, you two need to be separated as we talk,
But
then
that's not
that's
what
one
his
thing.
statements were. His statements
Yeah.
were very clearly, you don't have a choice right now, you need to go outside and talk to them. And then you gotta come outside and talk to this man. Stephanie, you have to come outside and talk to this man right here, please come outside and talk to him. I don't want the kid to hear the conversation you're gonna have, like you are going to have with this gentleman. He's standing in the doorway with no physical way for her to avoid it, and he won't let her excuse him out of the house either. There was no way for Stephanie to move Wong out of her house because he was refusing to leave, and he was then in between her and her child and out the door.
Okay, so they end up, well,
And, oh, sorry, there were still two more statements, like, I'm gonna stay right here, you're gonna go talk to them, that's how it has to be.
right, okay, so the second piece of the Miranda test
Yes, sir.
is whether the circumstances, quote, presented the same inherently coercive pressures as the type of station house questioning involved in Miranda. Okay, so they end up out on the landing and watch the videos, and I'm trying to think through, I mean, it's kind of a funny inquiry. Are we in a similar kind of coercive environment as a station house, whatever that means? One of the things that strikes me, I guess this is multiple of the things that strike me, they're in public, it's in the middle of the day, they're close to a street, you see cars, you hear cars. They're right next to a parking lot. As I was thinking through this case over the weekend and trying to think through what does that mean to be in a coercive environment like a station house, the thing I kept coming back to mentally, and I think some of the case law bears this out, is you're isolated in a station house. You're cut off from the world, and that sort of creates a little bit of a claustrophobia. And here she's anything but that. She's in public. I mean, yeah, you're right. She's bookended by a DCFS guy and an officer, but she's in public in the middle of the day. Tell me why that doesn't go strongly in the state's way on that second piece of Miranda.
You know, what the cases keep looking at is not necessarily the public part, but the support person. That was the thing that they focused on, so it's not just like,
What do you mean support person? What do you mean?
okay, so Lynham is the case that talks about when they use the child, basically potentially losing her children against her as a way to get her to talk. And one of the items that I believe I keep saying that. One of the items that the Supreme Court says was that she didn't have a support person in that case. And then that comes up also in, let's see, Beckwith, the person did have a support person because his friend was there. Let's see. Richie.
So I'm assuming you don't think that's a default rule that unless there's a support person, we're not
No,
in.
it's a totality circumstance.
So,
So
I
she
mean,
didn't have a support
Yeah,
person.
but you could have a scenario in which an officer is talking to somebody on the street in broad daylight, there's no support person involved, and we'd still think non-custodial interrogation, right?
But this is different because she's up on the second floor. There's nowhere for her to go. There's no one that's involved or going to get involved in stopping a conversation.
Right, but if one of the things we're being told in the red brief is that what the Miranda cases are after is this sort of oppressive station house kind of thing, we're worried about cops yelling, threatening, using physical violence and whatever. Here we are at 4 p.m. on a July day, and you can see cars in the videos. At one point in the videos, you can see another person walking down the stairs. And so it does seem like it would put some restraints on the officer's ability to threaten her violently, right?
Well, it doesn't just have to be violence.
Sure,
Miranda
sure.
talks about that. But I would also note that the officers had such control of the area, the apartment and landing outside, that when grandma shows up, who is a known person, they tell her to wait and to go wait in the car. Like, she's not permitted to enter even though she is a known figure. They have such control of the space that they're not permitting even known people to enter. They sent her away.
How much does that really matter, though? If you have an officer-citizen encounter on the side of the street, and some passerby comes walking up into the sort of zone, 3 feet away from the officer in the encounter, I imagine most officers are just gonna say, back up,
Well, the United States Supreme Court seems to think that it matters whether they have control of the situation and whether you can have, like, you're in a place where you have, people that make you feel comfortable or able to resist. And even one person that she did know that showed up on the scene was not permitted to be present. She was sent away. And so I think that shows that not only did the officers have control, or the government agents have control over Ms. Hansen, but they had control over the whole area. And again, even Miranda notes that the Fifth Amendment protection is all settings in which their freedom is curtailed. So we go back to looking at whether she was permitted to leave or move around, and it's again this very clear thing that you are going to participate, you don't have a choice, you don't have a choice, you don't have a choice. No reasonable person is going to sit there and think that they actually do have a choice when they're told exactly the opposite by the armed man in charge. Did anyone have any other questions? Okay, we did not get to our second point. Thank you for your time.
Thank you.
Your Honors, Counsel, may it please the court, Christopher Ballard, on behalf of the state. A person who has the freedom to control the circumstances of their interview is not in custody during that interview. The defendant had that freedom here, and therefore she was not in custody. And because she was not in custody during the first interview with the DCFS worker, the rule in Siebert and Uptain doesn't apply here.
Can I ask you, if the officers had said, just out loud, you are not free to leave, would that be problematic for your position?
Of course, it'd be problematic.
These repeated statements, I think the hardest part of your case is these repeated statements. You have to talk to that gentleman from DCFS, and I think you would concede, you can tell me if you don't, that under the circumstances, the communication was, we're not leaving until you talk to him. So this situation you're in is not going to stop until you talk to him. Is that a fair reading of that, of the circumstances? I mean, those were the words spoken, right? You have to talk to him.
Right, I agree that those were the words spoken. The words were, but you have to look at it in the full context. And I'm not sure, you say, is that a fair reading? I don't think it's a completely fair reading.
When my mom tells me I have to do something, to me, that means the debate is over, right?
But what I think the court needs to pay attention to is that the defendant had already agreed to talk with the officers before those statements were made. She'd not only agreed to talk with the officers, she'd also suggested that they go outside. And in answer to Judge Luthie's question, none of those, 0 is the number of statements, of these kinds of statements, that were made to her before she agreed to talk with the officers and before she suggested going outside.
Yeah, I mean, that was the line that you drew in the brief. I recognize you didn't write the brief, but that was the line that kept coming out in some form, was that this was a voluntary interview. And I take your point there, that she opens the door freely. She doesn't say, do I have to let you in? She opens the door. She then has that little exchange where she says, why don't we go out there on the landing? But then almost immediately there's that back and forth where she wants everybody to come out, and then the officers are saying, no, that's not what's happening. And that's when you get this whole sequence of statements. Officer Wong says, you don't have a choice right now. You need to go outside and talk to them. And it feels to me like the state is trying to tell us, and maybe I'm mischaracterizing the brief or your position, feel free to push back. It seems to me like the state's kind of saying, well, it was voluntary at the beginning, so that's it, full stop, it's voluntary. And I think what the defense is telling us is, okay, it may have been voluntary at the beginning, but the moment those officers start saying to her, quote, you don't have a choice right now, they've now turned it into something that's involuntary. Why is that view of this wrong?
Yeah, and to clarify, the state's position is not that because she voluntarily opened the door and agreed and suggested to go outside, that then somehow that's an immunization against any kind of coercion or restriction on her freedom. The state's position is that when you look at those statements that come after, first of all, and even backing up farther, you have the defendant inviting the officers into her apartment. She didn't have to do that. Nobody said, we have to talk to you. It was the DCFS worker who addressed the defendant and said, "I'd like to talk to you about your daughter." The defendant agreed, lets the officers in. And here's where you have the first instance of the defendant asserting control over the situation. The officers are going to close the door, I presume because the air conditioning's on inside the apartment, and they want to.
But this is my point. It feels to just putting the card on the table. It feels to me like there's a demarcation point. I'm taking everything you're saying right now. That in those initial minutes, plural, there's back and forth, thing with the door. They're talking about what to do with the child. But what feels to me like the striking moments is that exchange at the doorway,
Right.
where suddenly she's like, no. I don't want him in there. And then it's not just one of the officers, both officers make statements to her that are very definitive of, no, you're going out there and you're going to talk.
Yeah, and that's the whole reason we've got argument today, right?
Yes,
It's those
it is,
statements.
as it turns out.
It's those statements. And so, to put them in full context, is she's already agreed to speak. She's already exerting control over the circumstances of her interview, because she says, the officers go to close the door and she says, no, don't close the door. I'm feeling claustrophobic. So the officers are following her direction. And then she says, can we go outside? That's when we have the problematic statements. But she's already exerted control over the circumstances
if in that
of her
moment
interview.
when Officer Wong says, quote, I'm going to stay right here and you're going to go talk to them, okay? That's how it has to be. And if the test under step 1 of Miranda is, would a reasonable person feel free to terminate the encounter and leave? I'm having a really hard time imagining an armed officer saying, I'm going to stay right here and you're going to go talk to them. That's how it has to be. I'm having a hard time imagining a reasonable person saying, no, that's not how it has to be.
Right, because again, you've got, those statements are made in the context of they're not made in the context of the circumstances of her interview. They're made in the context of who's going to supervise the daughter during the interview that she suggested happens outside. And the officers say,
Can I just
Well,
clarify that?
sure.
Are you trying to draw a distinction then between the officers are not at that point saying this interview is going to happen? They're saying this interview must happen this way?
right, they're saying the interview that you have already agreed to is going to happen this way. And I guess let's be clear about what she's agreed to. Not only has she agreed to the interview and suggested that it happen outside, and the officers have complied because she doesn't want to interrupt her daughter's viewing of the movie. And then you've also got her, she's recognizing that the officers are complying with her request to not close the door when they first come in. And then she tells the officers, I understand that I can't be with my daughter during the interview. She says, I understand that. And so then what she wants is both officers outside with her. She doesn't want the one officer unsupervised with her daughter. And the officers aren't willing to just let the daughter, a 5-year-old, be supervised solely by the television.
But isn't it a possible reading of this whole thing that what she's really saying is, I would have agreed to an interview outside with all of you, but I'm not going to agree to this thing, which is what prompts them repeatedly to say, no, you are going out there. I mean, why can't she set the circumstances by which she's agreeing to be interviewed at all?
That's exactly what she did.
But then the officers tell her no. Then the officers say, no, you're going out there and I'm staying here. So
The line I'm drawing is between the circumstances of the interview and the supervision of her daughter. She's completely happy to have the interview. She's happy to have it outside. She wants both officers outside during the interview. She's happy to have the interview.
well,
And-
I mean, happy might be.
Right, that may be overstating
She
it.
doesn't seem thrilled about this whole encounter.
No, she's not.
She
She's
says
nervous,
at the beginning, she uses that phrase, I'm nervous.
just like anyone would be talking to officers, especially where, as she explained, she had her, the child's father call and say, they're gonna come and take the kid away.
Right.
So, and then again, continue looking at the totality of the circumstances, which is what the case law requires. So after those problematic statements are made, which I would contend have to do not with the circumstances of the interview, or at least are only tangentially related to that. They're dealing with the circumstances of the supervision of the
It's how the
daughter.
interview is going to be conducted, not whether it's going to be conducted. Is that the line you're having us draw?
It's how the daughter is going to be supervised during the interview that the defendant has already agreed to. And
So I drew a different line, and you've now drawn a different one, so again, I want to clarify. That
Sure.
it could be, you're going to be interviewed, period. It could be, you're going to be interviewed this way, and you're saying it's neither of those. It's actually, we see that you're agreeing to be interviewed this way. Your daughter is going to be supervised this way. That's,
Right.
that's what the interpretation you would like us to place
Right.
on those lines.
Right. The police are saying, we're going to require at least one officer to be in here with your daughter while you go outside and talk to that man. And then if you continue looking at the circumstances of the interview, you see the defendant directing those circumstances almost at every turn. You've got the defendant wanting the door cracked open a little bit further. The officer complies. Officer Asiata, who's the one outside, Officer Wong is inside. Officer Asiata, at defendant's request, cracks the door a little bit more. Then you have the defendant repositioning herself on the landing during the interview. She's got her back to the door. Sometimes she's got her shoulder to the door. She's only a step or two outside of her apartment. And then at one point, she interrupts the interview again and herself pushes the door open. There's no indication that Officer Wong is blocking her retreat back into her apartment. As Your Honor pointed out, that was never tested. But from everything I think an objective person in those circumstances would believe, where the officers are complying with that person's directions and not hindering that person's movement in any way, the person wouldn't feel like, oh, I can't end this interview and go back into my apartment. And then I think a critical piece of this that unfortunately got left out of the brief but is clear from the videos and has been mentioned a little bit is grandma's arrival. If you look at Officer Asiata's body cam starting at about the 16-minute mark, you see the grandmother arrive and interrupt the interview. And so to the extent defendant's claiming there was no support person there, the grandmother was there. And in fact, the grandmother addresses the defendant and says...
But then she's told to leave, which is their point about that, right? So the officers are keeping grandma away to some measure.
Actually, I don't ever hear anyone direct the grandmother to leave. What I hear in the video is the grandmother address the defendant and say, "Stephanie, are you okay?" And the defendant replies, "We're talking." And then Officer Asiata addresses the DCFS worker and says, "Do you want me to fill grandmother in on what's going on?" So again, suggesting this isn't a police interview, this is a DCFS worker interview. DCFS is in charge of this. And then you have the DCFS worker reply to Officer Asiata, "That's up to Stephanie." So whether grandma gets filled in about what's going on here and why Stephanie's being questioned by DCFS, what Stephanie hears, what an objectively reasonable person hears, is you're in control of what gets disclosed about the circumstances of this interview. And so again, that's on Officer Asiata's body cam from about the 16-minute mark to the 16:30 mark. So defendant has the freedom to control the circumstances of her interview. She did not have the freedom to control whether she could leave her daughter completely unsupervised. But that fact doesn't mean that she was in custody for the purposes of Miranda. And again, as even if we got to the second element of the inquiry, whether this was the same coercive pressures as the questioning, the station house questioning in Miranda, it clearly wasn't here. It's a DCFS worker. He's not in uniform. It's true that there were two fully uniformed officers. They had their handcuffs, they had their guns. They never displayed those. They never even made a move like they would.
I'm not sure what to do with the DCFS worker component of it. I've gone back and forth in my head on that. On the one hand, I totally take your point. He's a DCFS worker. He's in jeans and a polo shirt. He looks like he came from a barbecue. Totally get it. On the other hand, colloquially, when you sort of ask the layperson on the street, what does DCFS do? I think most people reflexively say something like, oh, they get involved and they take kids away. And so, okay, is he law enforcement? No. but he works for the agency that everybody sort of knows gets involved and takes kids away.
Yeah.
And she knows that that's what's going on. I mean, the words she uses when she's letting them into the apartment are, there was a threatening text, right? So she knows that what's happening here is really serious. And they've pointed to the case, IRS agents can be considered law enforcement for purposes maybe not law enforcement, but it matters. I'm not sure what to do with that part of it.
Well, to make it easy then, the state's not contending that this was not a government agent, that the DCFS, for purposes of this case, if she was in custody during the DCFS worker interview, the fact that he was just a DCFS worker who looked like he came from a barbecue wouldn't change the need for a Miranda warning here. But I think it's also important for the court to recognize that when she expressed that nervousness, that she had received a text or a call that people were coming to take the child away, the DCFS worker told her, that's not my goal.
Right.
My goal is to figure out, is your child safe? So, again, the defendant had the freedom to direct all of the circumstances of her interview. Miranda therefore was not required, and as has already been conceded, therefore we don't get to whether this was a two-step interrogation under Siebert and Obtain.
One question before you sit down that I wanted
Sure.
to make sure we pin down. I don't see a harmlessness argument from the state in the brief.
No.
So if we conclude that one or both pieces of this were improper, I think we have to reverse, given that we don't have a harmlessness argument. Fair or not fair? Like, suppose we thought, I've thought through sort of multiple iterations of this. Suppose we thought that the second, just suppose we thought there was a Miranda violation on either piece of this. If we don't have a harmlessness argument, I think we'd have to reverse the trial, right?
Yeah, I would agree with that.
Okay.
I think to the extent that her admissions were significant enough that they would not be harmless. And so I think that's why there's no harmlessness argument in the brief. Thanks.
Thank you. Ms. Frisk.
All right, a couple of points. I think it's really important as we're looking at all these different cases that talk about the way the different facts fall on different sides of the line, that the court remembers that none of the cases that certainly I found in the research and nothing that was briefed upheld as voluntary a statement that was made after someone was told by the police that they didn't have a choice except for to participate in the conversation.
What's your best response to the argument we've just been given from the state that they're not directing her as to whether the interview would happen, that what they're directing her is as to what's going to happen with the child during the interview?
There's a lot of subjective speculation as to intent contained in the state's argument there, and this is an objective inquiry. So the intent of the officer in whatever that was in making the statement doesn't really matter. It's the objective
Point taken,
situation.
but I think they're telling us that objectively speaking, if you look at the words that the officers are saying to her, that it's all within the context of where's the daughter going to be while we talk.
Well, there was an interesting switch in the state's argument from their briefing, where the briefing talked about it being, we need to separate you. Here, they're talking about, supervision of a 5-year-old. A 5-year-old can be in the living room while someone's standing right outside the door. Ms. Hansen is the parent. If she had control over her child and her apartment in that moment, could decide. But when she decided that the child was sitting right there on the other side of that wall and Wong did not need to be in there, Wong overrode her. And if the police can override the way that you're choosing to parent your children in your own home, you do not have control of your own home.
How do you respond about grandmother's interaction in light of how Mr. Ballard characterized that exchange?
They sent grandma away. I guess I'm just not understanding how them going down to talk to her. This again comes into the objective thing. So subjectively, we know that in this situation, grandma is not actually Stephanie's friend. Grandma is there as the DCFS person, like family contact, who's going to take the child. And in fact, does end up being the one that takes the child.
Does Stephanie know that in that moment?
She does not.
She does not know what?
She doesn't know that that's why grandma's there.
Okay, so then that seems, I think, to support their position, which is.
No, I didn't finish my thought.
Okay, fire away.
So the idea here is that we're looking at objectiveness. So objectively, a known person arrives at her home and is sent away by the government agents.
Okay, but now let me finish my thought.
Okay.
Before that happens, there seems to be this little snippet of dialogue. I have vaguish memories, but they're consistent with how Mr. Ballard characterized them. That when she shows up, that there is a little brief interaction with Stephanie. And so she's got a person who you just acknowledged, she doesn't know at that moment that that's why grandma's here. She just knows that her mother-in-law, ex-mother-in-law, shows up and asks her, how are you doing? That doesn't typically happen in a station house interview. I'm back to the second prong of Miranda. You don't typically have family members or support members showing up and just kind of walking into the room and saying, are you okay, right? So why doesn't this?
She also didn't agree that she was okay.
I'm sorry.
Ms. Hansen, in her response, did not say that she was in fact.
Right, but I'm not sure that's the real point there. I think the real point is if you've got a family member showing up mid-interview and having a brief dialogue with you, that makes it feel not station house-like to me.
I still think that when the officers continue to exert control over the environment by sending grandma away, that continues to show Ms. Hansen, who's detained there, that they have control over the situation. They're gonna decide who's coming and going. They're gonna decide who she gets to talk to, because they shut that conversation down real quick. She doesn't have the ability to access other people. She doesn't have her phone on her. They're in control. And I think there was a lot of conversation here about her agreeing to certain things, but I am not seeing where there was any kind of specific agreement that she was going to do anything. It's certainly not under the circumstances in which it was being presented. Sorry, I see again that I'm out of time. I didn't even get to the state's arguments about the second part. But if the court has any questions based on what they said, I'm happy to answer them. Otherwise, thank you. Okay,
Looks like we are good.
thank you.
Thank you both for your arguments here and in the briefing. They're helpful. And we'll take this matter under advisement and get you an opinion as soon as we can. And we'll now be in recess.